I would like to thank the New York Campaign for Alternatives to Isolated Confinement for inviting me to speak today. I'll try to outline the practice of solitary confinement and its relationship with international human rights law, and then I'll discuss the bill called Humane Alternatives to Long-Term HALT Solitary Confinement Act. The practice of solitary confinement is global in nature, and it's subject to widespread abuse. It is often imposed on prisoners for prolonged periods of time and for diverse purposes. When used in certain circumstances, solitary confinement may lead to the violation of fundamental human rights, including the right to personal, physical, or mental integrity, and may constitute cruel, inhuman, or degrading treatment, or even torture. In the thematic report on solitary confinement that I presented in October 2011 to the General Assembly of the United Nations, I defined solitary confinement in accordance with the Istanbul Statement on the use and effects of solitary confinement as a physical and social isolation of persons who remain confined to their cells between 22 to 24 hours a day. Although the specific form or context through which solitary confinement is applied, or even the name with which it is referred to, may vary, the fundamental characteristic of the practice is this absence of significant contact between the detainee and other individuals and with the outside world. Furthermore, given the fact that the physical and psychological harm associated with solitary confinement is often related to the duration of confinement, I define prolonged solitary confinement as any period of isolation which surpasses 15 days. Being one of my principal areas of concern, this definition was based on the large majority of scientific studies that indicate that after 15 days of isolation, harmful psychological effects often manifest and may even become irreversible. Significant access to human contact within and outside of prison, including contact with fellow prisoners and prison staff not strictly dedicated to security functions, are essential for the rehabilitation and psychological health of prisoners. These principles are established under Article 17 of the International Covenant on Civil and Political Rights and under the United Nations Standard Minimum Rules for the Treatment of Prisoners. Solitary confinement is often applied in such a manner so as to violate these principles, as well as to cause severe pain or suffering that in some circumstances constitutes cruel, inhuman, or degrading treatment, or even torture. Furthermore, due to the prisoner's lack of communication, as well as the lack of witnesses inside the prison, solitary confinement may also give rise to other acts of torture or ill treatment. It is well documented that solitary confinement can produce adverse health effects in an individual after only a few days, with the risk of serious and irreparable harm increasing with each day spent in solitary confinement. Research on the effects of solitary confinement has revealed certain psychotic disorders, including a syndrome known as prison psychosis, whose symptoms include anxiety, depression, irritability, cognitive disorders, hallucinations, paranoia, and self-inflicted injuries. In particular, prolonged solitary confinement may lead to the irreversibility of these effects. In my report, I concluded that the application of solitary confinement for more than 15 days in and of itself constitutes cruel, inhuman, or degrading treatment, or even torture, in violation of Article 7 of the International Covenant and Articles 1 and 6 of the Convention Against Torture, and should therefore be prohibited in all circumstances. A similar conclusion was reached by the Human Rights Committee of the United Nations in its General Comment number 20. Nevertheless, the use of prolonged solitary confinement as both a disciplinary or an administrative measure remains a common practice in many states throughout the world. Prolonged and indefinite solitary confinement should be prohibited under all circumstances. The greater the duration of solitary confinement and the greater the uncertainty surrounding the duration, the greater the risk that the prisoner will suffer serious and irreparable harm such as that would constitute cruel, inhuman, or degrading treatment or torture. While solitary confinement for short periods of time may be justified under certain circumstances, with adequate and effective safeguards in place, the use of prolonged or indefinite solitary confinement may never constitute a legitimate instrument of state. This is not to say, however, that solitary confinement lasting 15 days or less never constitutes ill treatment or torture. The assessment of whether solitary confinement amounts to torture and other cruel, inhuman, or degrading treatment or punishment should take into consideration all relevant circumstances on a case-by-case basis. These circumstances include the purpose of the application of solitary confinement, the conditions, length, and effects of the treatment, and of course the subjective conditions of each victim that may make him or her more or less vulnerable to those effects. Furthermore, in my report I found that solitary confinement of any duration should never be imposed on juveniles, persons with mental disabilities, and pregnant or breastfeeding women. Solitary confinement may only be used under exceptional circumstances and only as a measure of last resort. However, under no circumstance should solitary confinement be applied to children and persons with mental disabilities or pregnant women or breastfeeding women. Furthermore, in those cases where it is admissible, the duration must be as brief as possible and must be announced and communicated to the individual with the minimum due process guarantees. Persons being held in solitary confinement must be afforded with effective resources for challenging the reasons and the duration of their confinement and must be allowed access to legal advice and medical care. In this context, I welcome the introduction of the Humane Alternatives to Long-Term Solitary Confinement Act, also known by the acronym HALT. The Act is an important legislative response to the often extensive use of solitary confinement in prisons throughout the United States, and in this case, specifically in New York State. Last year, it was reported that almost 4,000 people were held in special housing units for up to 23 to 24 hours a day on any given day in New York State prisons, and often for nonviolent conduct. The HALT Act reflects both safe and effective prison policy, as well as respect for human rights. It should become law in New York State and a model for change across the United States. Its passage will ensure New York State meets its obligation with regard to torture and other forms of cruel, inhuman, and degrading treatment or punishment under international law. I am particularly supportive of the fact that the Act absolutely prohibits isolated confinement for persons under 21 years and over 55 years of age, for persons with physical, mental, or medical disabilities, for pregnant women, or for persons who are perceived to be LGBTI, or for purposes of protective custody generally. It is also essential that the Act prohibits isolated confinement for more than 15 days or 20 days in any 60-day period, and creates meaningful alternatives to isolated confinement in the form of residential rehabilitation units, RRU. Such secure units provide special programs, therapy, and at least 5 hours out-of-cell programming and recreation daily. They provide important alternatives to solitary confinement and can help foster rehabilitation and reduce recidivism. In this context, it is important to note that other states, including Maine, Mississippi, and Colorado, which have reformed their use of and significantly reduced the number of people held in solitary confinement, have seen a reduction in both prison violence and recidivism. The Act also importantly provides a number of procedural and due process protections for prisoners who may be or are placed in solitary confinement or RRUs. For instance, the Act requires the conduct of assessments to determine if persons belong to the special categories for which isolated confinement is prohibited prior to their placement, and allows legal representation by pro bono lawyers, law students, or approved paralegals at hearings. It also mandates that once an individual is placed in segregated confinement, he or she must be provided with a hearing within 72 hours to challenge the placement determination. In addition, the Act also provides for multiple levels of review at various time intervals to determine when a prisoner must be released from the RRU and mandates that persons must be released from RRUs after 1 year, unless otherwise mandated by exceptional circumstances and reviewed by an independent outside agency. For all of those reasons, it is my hope that the HALT Act will be adopted and create positive and meaningful changes in policy and practices in and reduce the use and severity of solitary confinement in prisons throughout the state of New York, while serving as a model for future changes throughout the United States and indeed throughout the world. Thank you very much.